Everyone, I am Nifemi Oguntoye. We start off at the National Assembly, where the House of Representatives has rescinded its decision to pass for second reading the bill seeking to remove immunity for vice president, state governors and their deputies. The lawmakers' decision on the bill seeking to abolish death penalty in the country was also reversed. The two bills are among the 42 that lawmakers passed for second reading yesterday. At today's plenary, Majority Leader Julius Nyowere moved the motion to reverse the decision on the bills. According to the Deputy Speaker, Benjamin Kalu, the decision is as a result of the sensitivity of the bills. Well, let's bring in public affairs analyst Olufemi Lawson for more on this development. Some say it's a joke taken too far to have seen that bill pass a second reading. Their thought is that governors will not seek to have that happen with their members in the House. What are your thoughts, Mr. Lawson?
Thank you, Nifemi. Thank you for having me. I think it is not the first time that this proposal is coming up in the life of the National Assembly. This has been a proposal that have not only been made by members of the House of Representatives, but by various organizations, even in the society in the past. But like it was said by the Deputy Speaker and the House Leader, it is such a sensitive no clause that they made attempt to introduce into our Constitution. Even the best democracy has, of course, presumed the United States of America have immunity for governors, president, and vice president. And the people who made this Constitution were deliberate. When you look at the reasons why the immunity clause exists in our Constitution, especially when you look at the type of politics we play in this part of the world, it is such that, if allowed, may lead to a situation where there can be instability in leadership. It does not foreclose the fact that persons can be prosecuted, persons can be tried, even after leaving office. We've seen people who have committed crimes, who have perpetrated, who have been accused of criminal conduct while in office, who are now being prosecuted by law enforcement organizations. I think it is just one wise thought on the part of the House of Representatives, more so that even if passed by the House of Representatives, remember the process of constitutional amendment is such that will take 2/3 of state House of Assemblies across the Federation to become the law. Then where do you get this 2/3 from? It will just be a wasted effort, because I don't see this kind of state assemblies that are mostly controlled by the state chief executive, by the governor, endorsing such a proposal from the National Assembly before becoming a part of our Constitution.
Absolutely. There are also other bold amendment bills, like having all the elections hold together in one day. There are moves as regards, for instance, quite a number of controversial attempts by the members of the House in this regard. But which one stands out for you in the 35 amendment bids?
Well, for me, let me refer to the question of having an harmonized date for elections. I think the House in that regard tried to put the cart before the horse. Recall that, for instance, local government elections cannot be determined by the National Assembly because these are elections conducted by constitutionally created state independent electoral commissions. Now that we have even off-season elections in Nigeria, are also as a result of the decision of the Supreme Court, starting from Mr. Peter Obi, to own those states, Ekiti, Osun, another state where we now have staggered elections. So rather than trying to harmonize, are we thinking about taking the power to conduct local government elections away from the state? Because the local government are creations of the state. So if you have not achieved that, then proposing an harmonized date, for elections in the country is just an exercise in futility until we are able to ensure that only one body, the Independent National Electoral Commission, INEC, is responsible for the conduct of all these elections, and that the needed, the needful is done rather by the Supreme Court on the validation of the tenure of office. It is very clear, the day you are sworn in is the day your 4 years are counting, by the virtue of that Supreme Court ruling. So, proposing that we have an harmonized day for all state election, presidential election, local government election, means you have to go back to the Supreme Court, or so that we can have those dates that are already staggered revised, and this may lead to shortchanging some of these persons who the Supreme Court ruling has actually validated their entitlement to 4 years in office.
Another of such bills is asking for an office of a prime minister. What are your thoughts?
And this is also it can only be possible in a parliamentary system of government. You cannot have a federal system of government, the presidential that we are running, and have a prime minister. In Nigeria, we understand that we model our democracy after, even though not yet truly federal as it should be in the sense of true federalism, but our model of democracy is such that recognizes the only three types of government, the executive, legislative, and judiciary, and it is only when we revert to the parliamentary system of government that we can be talking of a prime minister, as the case was in the First Republic. Then the president becomes ceremonial. You cannot have an executive president with the power that Constitution has given to our president as it is, and have a prime minister at the same time.
Public affairs analyst Femi Lawson, thank you for talking to us.